Welcome to the Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program has been created to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business regarding legal matters. We provide information and resources to help you decide whether or not you might want to contact a lawyer or handle some issues yourself. If you do need outside counsel, the idea is that you'll be better prepared, so will the attorney that you select. Our goal, as always, is to help you save money, save time, and achieve the best possible results. As always, we want to welcome Attorney David Bizarre from the Bizarre & Associates law firm in East Providence, because he continues to provide us with information, insights, legal information on the various topics that we tackle. So today, in view of the unusual circumstances presented in 2020, not the least of which has been the pandemic, we're going to discuss wills and estates, and we've done that before. But this time, the focus will be on the new issues, the new and sometimes limited opportunities that might be available to you, what you need to know. What does the doubling of the federal exemption brought about by that Tax Cuts and Jobs Act do for you or to you? Apparently, also, there's been a recent rise in the cases of fiduciary, probate, estate, litigation regarding some disgruntled beneficiaries. What does that do for you, or what do you need to know about it? So I guess we need to start by discussing or doing a quick tutorial on the fact that wills and estates, people use those terms interchangeably, David, but they shouldn't. So can you just do a quick distinction and help us stay clear on what they are?
Yeah, I think sometimes they use the phrases wills, trusts, and estates, and they are all really different things in many ways. So a will is a document where you dispose of your property at the end of your life, which is property that is in your name alone and therefore has to go through probate court, and the will has the instructions as to how you want to dispose of your property and the people who would be involved in helping do that, which is usually the executor or executrix, the personal representative. The estate is the formation of your assets or estate by the probate court at the time your will is probated. And so the estate representative, the executor or executrix, if there is a will, or the administrator or administratrix, if there's no will, is the person who's responsible for administering or settling your estate. A trust is a document that many people use, and there's a lot of different trusts. So in this context, we'll use it as a revocable living trust, or a document you design while you're alive, with three people who go into that: the trust maker or grantor or settlor of the trust, all the same person, the person who creates the trust. The trustee, generally, if it's a revocable living trust, it's the person who created the trust is usually the trustee for their own trust, and that means they're the ones responsible for managing the assets. And then the beneficiaries, again, you're usually the beneficiary of your own trust, and then the trust has instructions on what to do if you become disabled or when you pass.
Disabled, and then who you want to manage your financial affairs or other affairs as well.
Right. And in fact, in our documents, when we create them, we generally will be even more specific than just who is going to administer your trust for you or be the trustee of your trust while you're disabled, but what you want the trustee to do. Use the money to keep me at home if you want to be kept at home. Use the money to pay for my expenses, or other beneficiaries that you might want to be caring for at the same time if you have children, for example. So the administrative portion of that trust, or I should say the trust in terms of a disability, will have as many instructions in it perhaps as the administrative or part of the trust that is being used when you die.
And I guess while you're speaking of that, I think you should briefly perhaps explain what the living will is as part of those documents.
As opposed to a revocable living trust.
Fair enough.
So a living will is a document that we use to express your desires on health care, and particularly when you are towards the end of your life and you want the doctors or treating medical providers to know that if it's the case you don't want to be kept alive artificially, if there's no hope of recovery, if you're going to be in a persistent vegetative state, take measures to give me comfort only and don't unnecessarily revive me or intubate me or give me artificial feeding, that type of thing. And it's usually done hand in glove, I guess would be the expression, with or belt and suspenders with, in Massachusetts, a healthcare proxy, or in Rhode Island, a durable power of attorney for healthcare.
So in COVID land, since this has been a very strange time, situations have changed. Suddenly you become sick, and you've never been sick. You're a healthy person. You never had one of these. Now you suddenly might need one, and you might need it suddenly and immediately. How is that addressed at this point when there's social distancing, closed courts, closed attorneys, Zooms? How does that get handled, David?
So estate planning, because of the rules, particularly in Rhode Island with the need for witnesses to be present when you sign a will, we've been doing our meetings with our clients in person. And what we do in my office is I have 3 conference rooms. I rotate the conference rooms. I rotate the chairs in the conference room. We sit more than 12 feet apart, probably, in most of the conference rooms with our masks on. And for the purposes of signing those documents, particularly the will, it has to be done in person, and I did try when the pandemic was in full swing and the governor was issuing emergency order after emergency order to get her office to think about making video presence sufficient for in-person presence on wills, but she didn't think, her office didn't think she had the authority to amend the law to do that, so that didn't get done. So we've continued to have to see clients in person, and we just do it as safely as we can.
Sounds right. Apparently, because of COVID, there have been more cases of contentious issues regarding the designation of beneficiaries and people who were disgruntled about how that played out. What have you found? What do people need to know, and how do they prevent issues?
So it may be somewhat COVID related with some of the things because people are in a rush to get things done.
Exactly.
But it's always been an issue. And so we can go back centuries, probably, with people challenging wills and the disposition of property and so forth. So what we try to do is, if there's any question, we make sure that the people who are seeing the clients, the lawyer, and I always bring in a paralegal and perhaps 2, if there's any question about what they're doing, so that we can document the file and say, we met with them, these questions were asked, we thoroughly, if there's a question of undue influence or something, whoever that person might be, we have them leave the room, we talk to the client alone, and we make sure that they understand what they're doing, they know what they're doing, who their natural bounty is, what we would call it, would be, if they're cutting somebody out, why. So we go to great lengths to make sure that we're comfortable that the person had the mental capacity to make the decisions they're making, that there was no undue influence, and that that's all documented. Now, on top of that, some of the other things you raised are, all right, now the document says what the document says, and people may sue because they're saying the people who are responsible for carrying that out are breaching their fiduciary responsibility. So the executor of a will, the trustee of a trust, has a responsibility to the beneficiaries to make sure that they carry out the instructions given to them by the person who either died or created the trust in such a fashion that it's both economically done well and follows the rules or instructions of the trust. And that's where you might see someone getting sued for breach of fiduciary responsibility if they don't do what's required of them by the document that they're acting under.
We talked about who needs an estate plan. Usually the off-the-cuff comment is, only if you're wealthy you need one of those, and as we've discussed, no, that's not the case. Discuss, if you will, a little bit the idea of how that's changed now and what things that you might be inclined to re-examine, considering COVID caused people to not have jobs. Maybe their financial situation changed, or they had a business and it it plummeted in its value, and it's going to be going to the children and not, and skipping a generation. How has all that been affected recently, and what do you do to offset or plan for it, or help somebody plan for it? They don't know what they don't know, but you know. What do you do?
Not that it's been changed recently, but maybe people's focus is more on some of the other documents that are part of an estate plan. So an estate plan isn't just the trust or just the will. And the first part of your question about, well, I only need it if I'm wealthy, is certainly not true. The documents that are as important, and probably in some respects, in certain cases, more important than a will or a trust, the healthcare power of attorney, the living will, and a power of attorney for financial decisions. And so those documents avoid a guardianship. If you don't have those documents, who's going to be able to make those decisions for you if no one's empowered by you to do it through one of those documents? Probate court has to appoint a guardian to make those decisions, and that's a time-consuming, expensive, unnecessary process oftentimes, because you can make your own decisions as to who you want to help you with medical decisions and who you want to help you with financial decisions. And that's not necessarily the same person. You might have somebody in your family or someone close to you that you think is very astute with medical decisions and being able to talk to a doctor and making sure that they understand the situation that you're in. And of course, given the pandemic and all of the other concerns that can come up with health, that's really important. As you say, what's changed these days? Well, it's not changed, but the focus is probably more important that you have that healthcare document in place, so that not only do you have someone who can really advocate for you if you're unable to, but who also understands the decisions you would want to make if you get to the end. And so it's not black and white whether or not, you know, these documents say, don't put me on a ventilator or a respirator and do not resuscitate. The healthcare power of attorney, healthcare proxy, has the ability to get all the information, because through the pandemic and through COVID illnesses and stuff, oftentimes people were put on respirators or ventilators, and it wasn't necessarily the right decision, as we found, as part of how this unfolded, but maybe it was. And so someone needs to be able to make a medical decision for you if you can't. So no, I don't want to be on a ventilator to keep me alive if there's no chance of recovery, but yes, I want to be on a respirator or ventilator if it's a short-term fix to get me to a better place.
Presumably, you, in making these documents, you have a primary beneficiary, a secondary, I assume. So you, as an attorney, wouldn't be inclined to pick up the phone of every client that you've ever had who has had an estate plan in place and say, hi, is everybody healthy in your household? Do you need to change your designee because COVID hit them and something else happened? You don't need to be proactive in that case, I imagine. But if that's the case in that situation, how about over a period of time, somebody ended up with a divorce? Do you proactively have to contact the person who is divorced and say, you might want to change your beneficiary of your life insurance, or who's determining whether you live or die? How does that play out, David?
So if I only had the time to do that. But here's the thing. So anytime you have any life-changing event as part of your life, your family, somebody who you've used as an agent in your documents or a beneficiary, you should always contact the attorney that you want to use, who drafted those or is your attorney for estate planning, and ask to go in and see him or her and explain the situation and find out if you do need to change your documents. Sometimes you don't. So when we draft documents, we always ask and suggest and hope that they'll have backup people to do these roles, so that if you named one person and they're no longer available to do it or unable to do it, there's another person, and perhaps even a third or fourth person to do those things. So that's one of the aspects that we try to build into our documents. The second thing is on the beneficiaries. So, because you asked a lot of questions there. So on the beneficiaries, we usually have our documents done so that if we lose one of the beneficiaries before you, then there's a plan for that. And oftentimes it might be you have many children, and we usually will draft a document, perhaps we use the words per stirpes, which means I have 3 children. Each of my children has 3 children. If one of my children dies, their 1/3 share would go to their 3 children to be shared by them, so that they step into the shoes, so to speak, of their parent and are represented. If they don't have children, then it might go back to the other children who survive, or children who may have predeceased with their own children. That's what per stirpes would do. So that can be a way of dealing with that. We actually usually even go a step farther than that. And one of the attorneys I used to work with called it the nuclear war provision. So everybody who I've left it specifically to in my will, my children, my grandchildren, whatever, none of them have survived me. Well, where do you want it to go then? And there's a lot of different choices. Sometimes it's charity, sometimes it's other family members more remote, but in any event, that's something that we try to talk through, so that we do have provisions and contingencies for really almost anything that could happen. Sometimes not everything. And sometimes when there are changes, you want to change those things.
And speaking of changes, for those who have businesses and the business might be part of their trust and what their plan is, who's going to succeed them, or if they're going to dissolve it and what portion. Right, in the past X number of recent months, businesses have suffered, the assets have declined. Do you proactively, or do you wait for your person who has a trust to contact you to change something relative to that? If the businesses have declined, hopefully they've come back. Many have. The assets maybe are back in place, maybe they're not. What do you suggest, or what do you advise when people put their businesses in trust, considering what's going on right now?
So, just like we talk about when there's a change in the people who might be involved in the plan, when there's a change in the property that's involved in the plan, again, you have to go back, look at your plan, and decide whether or not it needs to be adapted for the changes that you've had. So, one of the things you talked about was there's a business. And let's take a hypothetical family situation where there's a business where one child is involved in the business and there are 2 other children who aren't involved in the business, and there's a lot of ways of dealing with that in your plan. But in this particular hypothetical situation, you left all of your other assets that you have to the other 2 children, and you left the business to the one child. So now, in your situation, the business is either, let's just say it's no longer existent, it just failed.
And many of those things
happen.
happen.
And it happens. So that's a time when you might want to go back and say, yeah, this failed and had nothing to do with the child who was going to get that business, who's been left out of everything else. But that's what it is. And what do I want to do now? Do I want to leave everything equally to all 3 children? Or it could be, let's just be on the other side of that, a situation where you've left it to that child, you've built the business up, that child's still involved, but now it's 5 times or 10 times the asset of all your other assets. And is that something you want to do, or do you want to include the other 2 children somehow in that? Which, of course, there's ways of doing. So the child who's been involved, you might want to leave in control and leave not maybe necessarily more of the asset, but the voting shares or control of the assets. You can divide the control of the business between voting and non-voting shares and still treat children equally. There's a lot of different ways to do that. And that's something, as an estate planning attorney, I often talk to clients about, and I listen to what they're trying to do and then tell them, well, the way you're trying to do it may not be the best way to do it. This might be another way to accomplish what you want to do. Treat all your children fairly. And fairly doesn't always mean equally, but treat them the way you really are trying to accomplish so that your wishes are carried out after you're not here.
Good example and good scenario, the way you've played that out. I guess this is probably a good time also to mention that one of the distinctions, as we've mentioned in the past, when someone has an estate plan, there's the issue about privacy. When there's a will, that's a public issue. If you really didn't want many people knowing who had what and who it's going to, that's one of the ways or one of the benefits of having a trust, because it remains private, and that's certainly a benefit. So mentioning that the downside of COVID, also in terms of the tax situation, and I know you've always mentioned that when we've had tax planning as a topic, you've always brought in a tax accountant to make sure that all of those bases are covered, and I don't want to put you on the spot because you are not a tax accountant, but certainly can address the issue. Knowing right now that there are tax benefits right now as it is 2020, would you be inclined to, even if you hadn't before, be inclined to bring that tax attorney in to say, if you're going to make some changes and take advantage of intergenerational opportunities and all the rest of these weeds that we wouldn't get into, are you more inclined to do that now because the tax situation is ripe for that, doing that?
Yeah, well, as an estate planning attorney, I need to be cognizant and aware of what changes there are that impact estate planning.
Yes.
And back in December, before COVID actually, there was a Secure Act change, which changed how you can withdraw money from retirement accounts depending on whether you're the spouse or another beneficiary.
Yes.
And it used to be we would draft trust with what we called conduit language, which means pass through the benefit of being able to take money out of an asset, a retirement asset, over the length of the beneficiary's lifetime. Well, if you're not the spouse, unless there's a couple of other exceptions that you fall into, you have to take that money out within 10 years. So we discuss this with our clients as we're either restating or redrafting documents and say, do we want that conduit language in there that might not apply anymore, or do we want to put in a language that says the trust can accumulate the asset, so there may be a higher tax on the income tax as it comes out, but it's now still protected by the confines or construct of the trust. So that's just one example of some of the changes that have come that you need to take into consideration. Of course, with the CARES Act this year, there were some changes with you don't even have to take that required minimum distribution in this particular year. And so how does that affect what you want to do, and whether or not, does it make sense to take it? Do you have to take it? Or can you say, no, let me leave it there and let it grow another year? So those are a number of issues.
And on that issue, also, wasn't the amount that they had to withdraw, hasn't that changed somehow too?
Well, when you have to start withdrawing,
yes.
It changed. It went to 72 from 70 and a half.
Yes.
The amount is calculated on the required minimum distribution on your age. So the amount on your own, the amount on inherited IRA after, or retirement account after 2019, beginning in 2020, that's only changed because you have to take it out within 10 years. But I don't read it as saying you have to take the same amount out each year. So you could take a look at, well, you know, I'm going to be working for the next 5 years. My income's going to be high, so I don't want to take it out in those 5 years. I'll take it out in the last 5 years, for example.
And another issue, so I guess it was in 2017, that jobs, what is it called, the Tax Cut Jobs Act?
Yeah.
So when that was passed in 2017, that impacted on tax law. What do you do when you are dealing with people who are going to be likely affected by that? Who should be aware, and how does it impact?
Well, that was more on income tax.
Yes.
And it had a bigger effect on corporations.
Yes.
It did affect everybody to some degree, but the biggest impact was on corporations and high net worth folks and that type of thing. And some people, again, now we're diving way out of estate planning and into taxes. You know, some people were affected because of deductibility of property tax and that type of thing. So
would someone likely go to you first to deal with who's getting what, and then the tax accountant to get into the weeds, so to speak, of that element, as well as I understand the charitable deductions and how those are itemized? That has become a little murky, where there are new opportunities for a short term anyway, but you wouldn't be expected to change that. Should someone go to the attorney first or to the accountant first, or you do it in tandem?
So here's the thing. A lot of what you just talked about are strictly accounting issues, and anything I said I disclaim here until you go to an accountant.
Okay, that's fair enough.
On the income tax side of it.
Yes.
But for example, if I have a client who is coming in who really wants to talk about creating something like the nature of a charitable remainder trust, which is a very specific trust that has many different income tax and estate tax implications, with that client, I may very well want to meet with them and their accountant at the same time. And the accountant and I can go back and forth with, well, here's the benefit from the estate tax, but here's the effect on the income tax, here's the benefit of the income tax, and here's how it can benefit you down the road. So a complex plan like that, I would want to meet with the accountant in the room, because we don't want to get into the situation, which we'll often get into, where I'll say that's an accountant question, the accountant say that's a lawyer question. Well, let's be in the same room so we can answer both questions at the same time.
Granted, those things can be complicated and take time. Wills, fast perhaps to do. Typically, when you're involved in something like this, does it take weeks or months to iron this out? Does it take only a few weeks, or is it a longer period of time? And the reason I ask this, as we're taping this now and we're in October, there are some certain tax advantages that may be in place right now, which come, not to be political, come January and going forward might impact on it. So what's your sense of the timing and when someone should be picking up the phone to call and make changes or at least review?
Yeah, so whatever changes may come, we're going to have to deal with whenever, if they come at all. So I wouldn't make my estate plan necessarily today based on what might happen tomorrow, because a lot of the stuff that is implicit on how it affects what you did doesn't happen until you die.
Yes.
And so we're not going to predict that. But what we can do is take advantage of whatever opportunities there are now if we thought they were going to go away. So
Exactly.
the answer to your question on terms of timing, it depends on how complex the plan is. If you started a will plan today and you designed it and you put it in place, it could be done very quickly. A trust,
Quickly meaning 2 weeks?
perhaps.
Perhaps? Okay.
You know, it
Realistic.
could be a little longer or a little less depending on people's schedules and availability, but it's not something
And
that...
COVID?
Yeah, and it's not something that is going to really, if it's done next week or the week after, depending on the person's personal situation, it's not going to really matter that much. The more complex things, like a trust, are first there's a design, then there's the drafting, and then the signing, and then what we do, which is really as important as all of that, is the funding, because the way a trust works is it only is effective on the assets that are put into the trust, or that the trust is the beneficiary of. So if you don't take the time, and as attorneys, that's something we work with our clients to make sure is done, to get it funded, then it's not as effective as it should, because you still have to probate things through what we call a pour-over will, where it pours it into the trust afterwards.
Good to know. I know we have very little time, but so many scammers out there. Apparently, online there are requests for people to settle up that trust estate plan very quickly. In 3 days, we can get you our money. Call now. To which you would say yes or no. Don't do that.
That's not how it works, and it would be a very bad idea.
Thank you. Needed to be said. We hope that this has been helpful to you in terms of your planning for yourself, your family, and your business. Please continue to stay tuned to The Law Matters. It matters to you. Thank you.